Hi, good good morning. Welcome to Law Life and Layouts, my YouTube channel. I am Narendra Sevi, retired higher secondary school teacher. Today I am going to discuss about Private Events BNS 2023 Series 1 Video 2. This is the continuation of Private Events Volume 1. Before watching this video, you shall go through Private Events Volume 1, which is seen in the playlist. Here the discussion starts from section 40 of BNS 2023. This video is a continuation of Private Events BNS 2023 Series 1 Video 1. Before watching this video, go through the video 1. Section 40, when private defense starts and when stops. Here discussing the duration of private defense execution. When a reasonable apprehension of danger arises in your mind, you start private defense and it continues till the offender stops commission of offense. That is, when a private defense starts and when it stops. When a reasonable apprehension of danger arises in your mind, you can start private defense and it continues till the offender stops commission of that offense. Private defense ends when danger ends. Revenge, retaliation or punishment is not a private defense. When you commit a revenge or retaliation or punishment of a person, it is not a private defense. There is a landmark case law, State of UP versus Ram Swarup, SC 1570 at 1974. The Supreme Court held that private defense should not be exercised to perform revenge against any person. Private defense should not be exercised to perform revenge of any person. Landmark case, State of UP versus Ram Swarup, SC 1570 1974. The Supreme Court held that private defense should not be exercised to perform revenge against a person. When the offender runs away from the scene, chasing and attacking him is not a private defense. When the offender runs away from the scene, chasing and attacking him is not a private defense. Then, if you do it, you are liable to offense. Section 41 to 43 stating about the private defense against offense upon property. Section 41 to 43 stating about the private defense against the offense upon property. There is private defense against the property. Section 41. What is Section 40? When the cause of death while offense against property. When can cause of death while offense against a property. When you apply private defense against offense against property, when can cause of death? 1. Robbery. Robbery means theft with violence. Robbery means theft with violence. Theft is taking place and the thief is trying to make a grievous hurt or death to you. It causes death during exercise private test. Then you retaliate to use defense by killing that person. That robbery. Then B is house breaking at night. House breaking at night means house breaking after sunset and before sunrise. House breaking at night. You can cause death while offence against your property. Then C is mischief by fire, explosive on house or tent or vessel. Mischief by fire, explosive on house or tent or what? When human dwelling house or tent or where property in your custody, where people are residing, if a person used mischief by fire or explosive on that house or tent, then you can cause death while exercising private defense. That to rescue that person inside the tent or house, you should use private defense and cause death of that offender. Then next one is theft, mischief or house past. Theft, mischief or house trespass, which causes reasonable application to grievous harm. When theft, taking loss or mischief or house trespass and the offender commit a grievous hurt to you or the to ready to kill you, you can cause death while exercising private defense. If the offender tries to kill you or give a grievous hurt, then you have reasonable apprehension, then you cause death while exercising private defense. When simple theft, it does not cause death. It is important that when simple theft, it does not cause death. Section 42. When death cannot cost in property waste. When death cannot cost properties. When there is a simple theft, simple mischief or simple criminal process in your property taking place, law should not be allowed to cost. When there is a simple trespass, you should not cause death to the offender. Section 43. When does private defense charge an against property defense? When the time duration of the private defense against the against the property defense, private defense against the property, the time duration. Here mentioned time period or private defense while against the property. One, when reasonable apprehension to danger to property starts private defense. When as soon as the reasonable apprehension of to danger to property, you can start private defense. It continues till the commission of offence take place, and it starts then it continues till the commission of offence take place. When robbery takes place, continue private defense till stop violence. When robbery taking place, you can continue private defense till stop the violence from the offender. Stop private defense after recovering the property. If you recover the property, then you can stop private defense. Or help from public authorities. If you can get help from public authorities, that is police or other persons, or the offender runs away from the scene, you should not use private defense after the help. You can get the help of private authorities or the police. When trespass or mischief occurs, private defense continues till the act is stopped. When trespass of your property or mischief to your property occurs, private defense continues till the act is stopped. Till the offender act stops his act, then you should not use private defense after that. When housebreaking happens at night, private defense continue till he stops the act or gets the help of police. When housebreaking happens at night, private defense continue till he stops the act or he runs away, or you can get the support from other people or police. You can stop the private defense. In case of property defense, law 41 to 43 is strict. The court taking the private defense law 41 to 43 is in strictly. But in case of defense in life is private defense leave section 38 to 40 law is liberal. That means why it is. Then when the defense in against the life, it is taking is liberal, because it is uh, you know that life is not, when life is lost, it is not repairable. But if you lost property, you can get back from that property by some way or another. So the in case of property defense, law is law to 41 to 43 is strict, but in case of defense 30 to 40, law is liberal. Section 44, risks to innocent person. Last section in this section, section 44. Law always protects innocent people, but sometimes law always for protecting your life by causing harm to innocent people. There is a necessity. Law always protects innocent people, you know it. But sometimes law allows for protecting your life by causing harm to innocent people. There is a necessity. If you do not exercise private defense, you have lost your life. Example, for example, in a tension between two group of people, a furious mob, including innocent children, attacking you. In a tension between two group of people, a furious mob, including innocent children, attacking you. When you start fire against the mob, the innocent children may be killed. When you start fire against the mob, the innocent children may be killed. But you should not mind it. Otherwise, your life would be lost. It is necessary to fire against the mob to disperse. Here, this section is concluded. The private defense, that is 34 to section 34 to 44. It concludes. For more notes, you can log into my blog. Thank you.